The Supreme Court of the U.S. decided in 2002 that people with intellectual disability could no longer be sentenced to death. Probably as many as 20 to 25% of people sentenced to death before this decision have intellectual disability. Ever since then, the question has been enforcing that decision in the states. Texas has been backward in a lot of ways on that.
The state of Texas is conducting its 600th execution since the end of the moratorium in 1976. Death Row Story is going to cover it, but let me tell you why there's a controversy around this one. Edward Lee Busby Jr., 53 years old, has an execution scheduled Thursday, May 16th, 2026. What he did was horrible. In 2004, he kidnapped a woman from a Fort Worth grocery store parking lot. He robbed her, placed tape over her mouth and nose, causing her death. Her name was Laura Lee Crane. She was 77. We must all think about her husband, her daughters, her son, and her grandchildren. She was a random target. Busby was 31 at that time. He had a female accomplice. She received a life imprisonment sentence in 2006. Busby received a death sentence in 2005. In 2021, he had an execution date, but the Texas CCA Criminal Court of Appeal granted a stay to allow the review of his intellectual disability claim. Because it's forbidden to execute people with such a condition, that's what the US Supreme Court ruled in 2002. Two experts were appointed to decide whether this applied to Busby, one chosen by the defense and the other one by the prosecution, the Tarrant County Attorney's Office. Both reached the same conclusion: Busby is intellectually disabled, but the trial court rejected their findings. And the CCA said, okay, that's fair. He can go back to death row because a judge doesn't agree with two experts' findings. Today, the case is in front of the US Supreme Court. The defense says a court cannot ignore unanimous clinical opinions and substitute its own judicial reasoning. It violates another Supreme Court decision saying that courts must rely on current medical standards. And the state of Texas says that courts can reject experts' conclusions if they find the underlying evidence unpersuasive. In 2022, I interviewed Richard Burr, an attorney with deep expertise in intellectual disability and mental health evidence. He even worked on the case that led to the 2002 decision from the Supreme Court to ban the killing of people who have intellectual disabilities. Here's what he said.
The law says that intellectual disability means what it does in the clinical world, and that has three parts: significant limitations in intellectual functioning, significant limitations in adaptive behavior, and manifestations of that before you become an adult, in what's called the developmental period. Usually the 18 years or younger, but now the developmental period is more in the early 20s. We measure intellectual disability by primarily two things. One, intellectual testing, an IQ test, and the full-scale score on that has to be 75 or lower, and adaptive behavior deficits in one of three areas: conceptual, social, or practical. And what that means is difficulty functioning in the world, conceptually, socially, or taking care of yourself. Intellectual disability has, since 2002, has become a reason to prohibit people from being sentenced to death. The Supreme Court of the U.S. decided in 2002 that people with intellectual disability could no longer be sentenced to death. So even if you're sentenced to death, you can come back and try to show that you have intellectual disability, and that will get you off of death row. The difference between mental illness and intellectual disability primarily is mental illness usually involves a misperception of reality. You see things that aren't there, you hear things that aren't there, You have ideas like called delusions that are just not based in reality. People with intellectual disability, they may have mental illness too, but the intellectual disability is not that. It is a difficulty understanding what's going on in your life and in the world in such a way that it interferes with your ability to live in the world independently and successfully. They can overlap in some ways, but you can have a very high IQ and be severely mentally ill. You can have a very low IQ and have no mental illness. So they're separate entities. Mental illness has not become a reason to keep you from being sentenced to death completely. It is a reason called a mitigating circumstance. That is a reason calling for a sentence less than death, but it's not required. There is some movement in the states to prevent the sentencing to death of people who have severe mental illness, but it's still just a few states that have the death penalty that do that. When a majority of the death penalty states have come to that same conclusion, then the U.S. Supreme Court would probably say it violates the Constitution for people with severe mental illness to be sentenced to death, but we're not there yet. The number of people sentenced to death before this decision by the Supreme Court who might have intellectual disability, it's a little hard to determine, but probably as many as 20 to 25% of the people on death row have a real question about whether they have intellectual disability. And when I say that, you have to investigate it fully to be sure. And then a court has to decide that you do have intellectual disability. And there can be disagreements about that. But probably as many as 20 to 25% of people sentenced to death before this decision have intellectual disability. The number of people still on death row who have intellectual disability is diminishing because a number of those people have brought claims of intellectual disability and have been found to have it and released from death row. But probably there are 10 to 15% of the people on death row who have actual intellectual disability. I don't know whether there are more in Texas than in other states. There may well be because the Texas legal system is so flawed. Flawed in many respects. Inadequate lawyers defending people, inadequate resources to investigate and get expert assistance, and biased courts. So it may be worse in Texas than other states, but I'm sure there are people on death row in other states who have intellectual disability too. The case in which the Supreme Court held that people with intellectual disability can no longer be sentenced to death is a case of a man from Virginia named Daryl Atkins. The Supreme Court had been suggesting for several years before they took his case that they were interested in that question. They took a case from North Carolina that had that question and then decided that was a premature decision to consider it. When they took Daryl Atkins' case, it was clear that was going to be the case they would make this decision on. There were a lot of national advocates for people with mental health disorders and intellectual disability who helped to develop the case and present it to the Supreme Court. The man who was the president of the American Association on Intellectual and Developmental Disabilities argued the case to the Supreme Court. And it won. It was a successful decision in 2002. Ever since then, the question has been enforcing that decision in the states. Texas has been backward in a lot of ways on that, and it took two decisions by the Supreme Court in 2017 and 2018 in a Texas death penalty case for the law to start really being followed in Texas. In the lead up to the Daryl Atkins case, I was involved in helping put the case together. I worked closely with a lawyer who presented the case to the Supreme Court. And then afterward, I and another lawyer from Florida represented Daryl Atkins in the courts in Virginia to determine whether he actually had intellectual disability. The Supreme Court said, if he has it, then it violates the Constitution. Now go see if he has it. And I was representing him in the part about seeing whether he actually had intellectual disability. Determining whether somebody has intellectual disability is a complicated process. There are some cases that are clear-cut, where people's school records show they struggled continually in school. There were IQ tests given in school that showed intellectual disability. People were in special education. They had problems living. And in those cases, usually there's an agreement between the defense and the prosecution that the person has intellectual disability. In more cases, though, there is a disagreement. And it's about how you interpret the facts. IQ testing can go different ways and be interpreted different ways by experts. Sometimes reasonably in both directions, but usually not. But whenever the prosecution opposes the finding of intellectual disability, it becomes much more difficult because the courts everywhere, and especially in Texas, are biased towards the prosecution. So they will tend to credit what experts for the prosecution say more than what experts for the defense say. And there is a question of what's called malingering, whether you are actually trying your best on an IQ test or not. I mean, again, there are ways to determine that, but it can get murky. And then the witnesses who are talking about adaptive behavior are always people who are from the family or friends, or want to see the person not be sentenced to death anymore. And so the courts assume that they're biased in favor of the person on death row. So it's a very complicated and difficult process.
Death Row Stories will continue to follow up with this case.